I think most of you know me, but I'll just introduce myself. My name's Daniel Monk. I'm the Professor of Law, and I've been running this legal practice conversation for about 8 or so years. And it's a great opportunity to talk to a legal practitioner. Legal practitioners and legal academics don't talk to each other enough, unfortunately. So it's great to have this opportunity. And often what comes up in these conversations is that what we teach and what practitioners are doing are often quite different. And we're going to have an opportunity to think about that a bit later. It gives me enormous pleasure to introduce Elizabeth Isaacs. Do you go by Elizabeth or Liz?
No, Liz. Only my mum calls me Elizabeth.
Oh, I'm just reading your name on the thing. Okay, so we'll call you Liz here. Liz Isaacs, KC, which I'm taking a while to get used to, King's Counsel, and an arbitrator, which is also something interesting to think about, barrister, head of chambers, and deputy High Court judge. So welcome so much, Liz, to Bert Beck's Legal Practice Conversation series. The format for the evening is that Liz and I are going to have a chat, a conversation for about half an hour or 35 minutes, something like that. And then what we will do is open the floor to enable everybody else to ask your questions. And your questions can be about what we've been talking about, the case we're going to discuss, and really anything else you would like to ask a barrister and a legal practitioner. So welcome, Liz. I want to start by asking some questions. Someone's coming in. I want to start by asking some questions just about your career and how you got to where you are. So we're going to go back in time a little bit.
Okay.
So I'm going to start by asking you, how did you become a lawyer? And why did you want to become a lawyer? Tell me that story.
Okay, well, I'll try and keep it short, but it is a bit of a long story. So I am now 59. I went to Durham University to do an undergraduate degree in psychology. I didn't know what psychology was. It sounded quite interesting. I had no idea. When I got there, I didn't like it, wasn't very good at it. That I graduated from that in 1984. So it was at the height of the Thatcherite sort of era, when all my friends were going off to be bankers and work in industry. And I just knew that I didn't want to do that. So I just knew that I wanted to do something helpful. There wasn't much I could do with a psychology degree. So I went off to be a social worker, and I went to work with homeless people, first of all, because in those days, it was actually very difficult to get onto a social work training course. It's quite easy now, I think, but it was very difficult then. And you had to have 3 years practical experience. So I went to be a youth worker, worked at the Citizens Advice Bureau, worked with homeless men mostly in Coventry for an organisation called the Cyrenians. And then I worked with troubled young care leavers and all of that. And I was a youth worker in girls' work and so on. And all of that was designed to get me some experience. I then went off to Leicester University and did a master's degree in social work, which I really loved and was much better at that than I had been at the psychology degree. And then from there, I went to become a social worker. I was a hospital social worker for a year, and then I became a child protection social worker. And really quickly, this was in the early 90s, realised that although I really liked social work, I wasn't very good at being employed, and I was even worse at being an employee of a local authority. And by that point, I had a baby, and I had a mortgage and a house, and I couldn't do anything else. So Coventry University was one of the very first new universities in the early 90s who were offering part-time law degrees, and I couldn't afford to give up my job and go off and do what was then called the CPE, which is the law conversion course. It's probably called something different now. Is it the GDL maybe? I don't know.
SQE.
SQE, I don't even want to know what that stands for. Okay. And I couldn't afford to do that. And I thought, actually, I really want to, I was always really interested in law, and I probably should have done that in the first place rather than psychology. But I just went to an ordinary school where nobody said that was a good thing to do. And so I started doing the law degree part-time in the evenings while I was working full-time. So I imagine what quite a lot of your students are doing right now. So I do feel your pain. And I look back now and think I have no idea how I did it. So I was working as a child protection social worker 9 to 5. I moved to a job that allowed me to be a bit more 9 to 5 rather than going out on duty. And I just used to do what all of you do, I'm sure, which is I used to set the alarm, get up at 4, 5 o'clock, do work before I went to work, or at the weekends before my little girl got up, and used my leave to do my essays and all the rest of it. I didn't have a computer. This is how long ago we're talking, early 90s. And then that course, they gave me a year off for good behaviour, my antecedents, but it still took me 4 years to do that law degree. And about halfway through, I was going to be a solicitor. And about halfway through, I did a case as a social worker. I went to court to give evidence, and it was a really nasty abuse case. And it was my first exposure to barristers, because they were cross-examining me. And I, in a way that a good barrister makes it look really easy, I thought, well, how hard can that be? That looks fun. That looks really nice. And so I started looking into it a bit more. This is all before the internet. You had to write off to places and wait for weeks to get replies for anything. And I then used some annual leave to go and do mini pupilages, which are sort of weeks where you shadow barristers. And I just absolutely loved it. The minute I stepped foot into a barrister's chambers, completely loved it. And then I applied for bar school. And at the time, it was the first year that they just started offering it outside London. And I could have done it in Nottingham, but everyone said it's a bit risky. Nobody knows how these regional courses are going to go. So I applied to the Inns of Court School of Law, which is now part of City University. And so my little girl was 5 when I started that. No, 4. And I just lived in London in the week and went back at weekends and did that for a year. And then I applied for pupillage while I was doing that course, and was really lucky to get a scholarship pupillage in Birmingham, which meant that I could then go back. And then that's how I got into the law.
Oh, that's an amazing story. Thank you. And it's a really inspiring story and really pertinent. And it's great for Birkbeck students in particular to hear that, because actually, for 2 things, studying part-time in the evening and actually making a change of profession and going into a little bit later. Did you come across any barriers, do you think, people in terms of age discrimination and just going into the profession a little bit later? How did you deal with that?
Definitely. It was really difficult. I mean, we're talking 25 years ago. And so I was 35 when I started in pupillage, or 34. I think I said I had to be 35. And I remember going to pupillage fairs, which some of your students will undoubtedly have visited or been to, and asking a few people at various stalls, what's your policy or approach to older students? And at the age of 59, I now look back and think I was a bright young thing, but at the time I felt very old. And several people said, well, you know, we don't really take people that old, you know, just have to apply with everybody else. I mean, it's just unheard of now. Now I think the bar is much more welcoming to older people. And the other thing that was difficult is that I'm a lesbian and I had a little girl, and the bar then was a really different place to what it is now. And so I didn't feel able to come out at any point until probably at least a third of the way into pupillage. And I had the good fortune to end up at a really welcoming, decent criminal set in Birmingham who just were great. But it was a really different, it's quite difficult to explain what a different world it was then. So I'd say, yeah, there were barriers. And the other thing is, I was acutely aware geographically I was limited. I couldn't go anywhere outside the Midlands because I had a mortgage and a partner and a baby and all those things.
No, it is really interesting when one hears some of the stories from the past. I certainly remember, and it's really shocking, the explicit, blatant levels of discrimination. So it's really, it's awful to hear that, but it's also encouraging to hear that those things have changed much more. I think there's a real generational shift, isn't there, about those things. We'll come on to talk about those things perhaps a bit later as well. It's interesting that you found out about law just by that case you were involved in when you went to court, because actually a lot of the students I know who are social workers, they've come to study law precisely because they're in court quite a lot. And one of the reasons why legal professional solicitors firms and barristers chambers like mature students is because they've been working with law and they've got experience of law. So I wonder, I'm surprised you said it was just that court case. Hadn't you been working with law the whole time as a social worker?
Yeah, totally. I mean, when I did the master's course, I mean, I was a really bad undergraduate, I can tell you. I just did all the things you're not supposed to do. I didn't apply myself, got a pretty poor 2-2. Frankly, that was a miracle. And when I went to Leicester to do the master's, I was older and I thought, right, I better just apply myself a bit here and do some work. And actually, I really loved studying that master's. And one of the things I loved was we did a really great law module on that course. We were taught by Professor Judith Masson, who is, I think, still at Bristol University, but she was my tutor and my lecturer. And she was just a great teacher. And so, yeah, I suppose that sort of kindled my interest. And then when I went off to be a child protection social worker, of course, you're grappling with the law. And I also had the good fortune to be training as a social worker at the point that the Children Act came in. And so we were taught the old law, but we were also taught the new law. And I just really took to it. It really sort of lit a fire in me. And I suppose, yeah, as a social worker, you're applying the law all the time. And I'm quite a logical person, obviously, and I think in a very systematic way. And so everything to do with evidence just really interested me in thinking in that way and building a case. So, yeah, that wasn't the first case, but that was the one that made me want to go to the bar as opposed to be a solicitor.
Right. And when you're cross-examining a social worker now, do you think that gives you the edge, or do you know how to be a tougher cross-examiner because you know exactly what they're dealing with?
It certainly gives me a lot of insight into how social workers think. I mean, I think when you've had a social science training, you grasp concepts that perhaps if you haven't had that training, you do. So I tend to think about things in quite a global way. I think about things like structural inequality, I think about poverty, I think about the impact of circumstance and wider factors on people's lives, and that helps me try and get into a case and think about the case theory a bit more. I also think I've had some quite good results. Sometimes I've had some dreadful results, but sometimes I've had good results just trying to unpick how social workers actually made decisions. So one of the very early things I do in preparing a case is to do a chronology, a detailed chronology, and look at where the decision making was and what happened and trying to spot patterns. And so one memorable example is when I knew that a social worker's change of heart, for which there were no real reasons about why she had changed from returning a baby to my client, who was an ex-alcoholic, to adoption, plan of adoption. And she'd seemingly just changed her mind over about 4 days with no real evidence as to why. Because I know that social workers make decisions on the hoof, often in corridors, over a cup of tea, on the phone to their manager. That's how I cross-examined her, and that's what happened. She'd made the decision, in her car on a Friday afternoon while she was chatting to her manager. So I think it gives you that insight. It's also really helpful representing social workers, because I think I'm really sympathetic to the stresses. I think it's a massively underrated profession. I think social workers just deserve medals, particularly how they work during COVID. Oh my God. So yeah, I think it is helpful. It's helpful, but I'm glad I'm not one now. Yeah.
Right. Now, I wonder if you can talk a little bit about the law that you ended up specializing in, and whether it was easy to specialize, or did you have to start as sort of a generalist when you got your started getting a place in chambers?
Well, as I said, when I got a pupillage offer, I went to a largely criminal set in Birmingham, but they did have a small family team. There were about 10 people who did family. And as you said earlier, the fact that I was a mature candidate was really helpful. So it meant I got a kind of head start. So quite quickly, although I did crime and I did some civil as well, but I mainly very quickly started doing family. And then I got a couple of lucky breaks, as often happens. Somebody who did a lot of work for Birmingham City Council went to China for 3 weeks. So I picked up some of her returns. And that's often what happens at the bar. You just fall into work because you get a lucky break.
I've never heard of that before. That sounds, it's like being on stage and, you know, the understudy goes on because the lead has an accident,
yes,
or someone goes off to try and suddenly you get your big break.
Yeah,
I've never heard someone talk about that. I got a big break, right? And suddenly you're on because of the case.
But that's exactly what did happen. So I then ended up just doing tons of work for Birmingham City Council. And it's just the most fantastic training. And that was in family law. So that was going to do applications for emergency removals, going to the magistrates court a lot, and doing public law, which is what I did as a social worker and what I do now mainly.
Do you do private law as well? Do you do private family law? So could you tell us a little bit about the range of your actual practice and how possible it is to do different types of work?
Definitely. Well, I probably carried on doing the crime and the civil for about 3 years into practice. And then because I was older, I could specialise more quickly. Nowadays, in my own chambers, people seem to specialise a lot more quickly. So we have people 2 years in saying, that's it, I want to ditch the crime. I did do the full gamut of private law. So that is anything from applications for temporary relocation. One parent lives in Swindon and wants to move to Glasgow with their child and the other partner doesn't agree. So those kind of applications about how much contact the non-resident parent should have, all those kind of things. And then when I took Silk, by the time I took Silk, I pretty much stopped doing that kind of work. Since I've taken Silk, I've done a little bit more again. And then I really developed quite quickly in Silk a practice doing surrogacy law and fertility law. And that's a branch of private law, I would say. And that practice has developed wholly in the last 10 years.
Right, that's really interesting. So when you say took Silk, that means you're becoming a senior barrister and becoming a QC, now a KC.
Yeah.
That's interesting that you did crime, because my experience of younger barristers is that they're very specialised, and the idea you do crime and civil at the same time, that's almost unheard of now. It seems quite unusual. So how in control do you feel you are of your practice in terms of saying, I'm just not doing private anymore? What about, how does the cab rank rule? Perhaps you could say something about that. I mean, presumably, my understanding of the cab rank rule for barristers, you take what comes in. So how can you, is it just because you get known for doing things? So how does it work if you say, right, I really want to focus on this now, but I don't want to do that? How do you do that?
I mean, I can only speak from my own experience, but also I can speak about being head of chambers and watching the young ones in chambers. Young ones, I sound really old. I am really old.
No.
So when I started, quite quickly, because I was older, because I'd been a social worker, and I like to think I was reasonably good at the job, I got a reputation quite quickly for doing care work. And that's what happens. You get a reputation if you're reasonably good at the job. And so then solicitors will ring up your clerks and say, I want to book Miss Isaacs to do a 3-day case in Burton-on-Trent Magistrates Court. And then what happens is, I always describe it as like a set of steps. Being at the bar is not like this. You don't just sort of start there and rise up like that in terms of the level of your work. I see it very much more like this. Okay, so you cruise along, you're quite happy in your lane. Then you get the case from hell. You think, oh my God, I have no idea what I'm doing. I don't know how to do it. But you do learn how to do it. It might be at a different level of court. It might be a longer case than you're used to. I remember the first case I did away from home, from my home court, was in Norwich. I went to Norwich for 3 days. I thought I was absolutely made then. Then later on, I got a 7-day case in Sheffield. And so the cases start getting longer, or they get more complicated, or they become in more a higher level courts. And then what happens is your clerks say, well, there's a choice. You can have this case public law next Tuesday, or I've got this private law dispute in Burton-on-Trent. And then the clerks just start making choices for you. You don't often get involved in that at that stage. And then usually down the line, you might have a conversation with your clerks. That's how it works in my chambers. And you say, look, I really think the time has come now. Don't put me forward for any more crime, or don't put me forward for private law. So that's how the cab rank rules. Technically, you're not supposed to say no to anything. If it comes along and you're like a taxi driver, you just take what case is next in the queue. But I'm afraid there are ways you can get around it. I'm not saying that people don't, you know, try and get around it. You shouldn't write that down, really.
No, and I'm sure the clients, the solicitors, local authorities, they know who they request people once you get a reputation for something, I'm sure. And then the expertise.
Totally. Yeah, and so
particularly if you've got silk, you're dealing with more complex cases,
Yeah.
presumably. So that experience becomes more important.
The rules have also changed in the last decade or so to say that you're allowed to refuse a case if it's not properly remunerated. So what that means is if you are approached to do a case and you and your clerks decide that the fee is not right, it's not commensurate with the work you would do, you are not in breach of the professional code of conduct to say, I'm not going to take that case. So I probably not a week goes by where I don't get a direct access request. So that's a member of the public writes to me directly. They've seen me online and they write, and you know, sometimes they're good cases, quite often they're dreadful. And in those cases, the clerks will screen them out, and usually the way they'll screen them out is they'll say, truthfully, this is what Miss Isaac's hourly rate is, and the client won't want to instruct me. But on the other hand, I'll often do pro bono work. I'll do free work, not often, but I mean, I will do a certain amount every year.
Yeah, yeah. That's really interesting. And it's really interesting here about the nuts and bolts of practice in that way. There's some really interesting questions coming up in the chat about some family law issues, which we're going to come back to later, I promise. I have spotted them, everybody, and we're definitely going to come back to them. But I wonder if you could tell me a bit about what your typical day is like.
Okay, what now?
Most people think barristers, you know, you're there in your wig and you're in court.
Okay, well, I'll tell you about today, because that is a very typical day. So this morning I wake up about 6. I check my emails because I'm quite sad. I can see that something I was working on till about 7 o'clock last night, some urgent extra papers had come in for something that I'm writing an advice about, and I'm also having to draft a document for the court hearing in that case. I'll call that the Smith case. That's not the name of the case. But I was drafting some papers in the Smith case first thing, and just basically sending some correspondence. Somebody's making an application to vacate the hearing on Tuesday, so I had to prioritise dealing with that over everything else because that's urgent. Then I went swimming and had some breakfast, walked my dog, and then I had a consultation at 9:30 with the junior, so that's my junior barrister that I'm leading in a case that I was doing remotely today in Brighton, and I'll call that the Jones case. And I had to talk to her about how we were going to manage our client who wanted to join the hearing, but he's 17, he's very vulnerable, he's got learning difficulties, he's got Asperger's syndrome, and he finds it really hard to concentrate. And so he has what we call an intermediary, like an advocate who's trained in helping him communicate with us and us with him. And again, that's where it's helpful that I was a social worker, because I think I'm reasonably all right at communicating. So I was talking to the junior about how we were going to manage the practicalities of the day. So she was down in Brighton in her chambers with the client. I'm up here where I live, and we had to talk about the practicalities. At 10 o'clock, I then received the judgment in a case that I've just finished doing, where I've been in Preston all week. So I had to read the judgment, see what the result was, see whether I'd won or not. Think about it, whether any issues were arising from that judgment, send some emails about that, while at 10:30 joining the Brighton hearing remotely. So I'm sort of on screen in the Brighton hearing, over here dealing with the judgment. At 12 o'clock, I had to leave the Brighton hearing briefly to join the Preston hearing to get what we call hand down, where the judge says I'm formally handing down the judgment. had to make an application about something in that case. And by 12:30, I was then back in the Preston case. Had some lunch about 1:30 when that case finished. Then did some more work on the Jones case, the one for Tuesday. Read some stuff about equality and diversities, which I'm dealing with in my job as head of chambers, and then had a meeting with our equality and diversity person in chambers and someone else. Then I reread the case of Re C that you and I are going to talk about, looked at your list of questions, got a glass of fake wine, and then joined you. That's my day.
I mean, what's interesting about that, and we're going to come on to talk about it in a moment when we talk about the case, is how that's probably a very different day from what your life would have been before COVID and before we got used to being online.
Yeah.
Like so many people, it's just been such a game changer.
Yeah.
And what to talk about online justice, which is a key theme for first year studying legal system and method. We have a whole set of things next term we're talking about. I started introducing online justice as an issue in the legal systems and methods course about 5 years ago. And it was this conversation of some people talking about, and then COVID came along. And then of course, online justice it's not this hypothetical thing. It's not this maybe, maybe not. Should we trial it? It's like everybody's trying it. It's happening. It's a reality. And it was the most extraordinary experiment. I mean, it wasn't just a pilot project. It was this real out there experiment that everybody's still dealing with now. I think actually on that note, let's turn to the case actually, because there's lots of things to talk about in that case. So this case, which I'm really great, and I think everybody's had the chance to have a quick look at it, but I'm not going to assume anybody's read it at all. In some ways, it's quite a simple case in that it's about an the question is, should a trial go ahead or not go? Should a trial go ahead with a participant's barrister only be able to attend online, or will the fact that one of the parties' barristers can only attend online, is that so detrimental to the party's fair trial that the case should not go ahead online? And as the judge said in the case, and there's a great quote from the judge, I think at the top, he says, "There's no perfect solution to this. It is a clash of rights." And many of the issues we deal with while we're studying law can be described as a clash of rights. Rights rarely resolve an issue. It's rather, you've generally got rights on both sides. And here with this classic case, you've got a right to fair trial, which means you're arguing that the woman you're representing needs her barrister in court for it to be a fair trial. On the other side, they're saying no delay is really detrimental to children, and it's a child's right for these cases to be heard very quickly. I mean, that's very, very crudely summarised it for people who perhaps hadn't had a chance to read it. What struck me as really interesting is that you're acting in a case that was all about you as the barrister, and that was so unusual. It took me a while to sort of gauge that, because you were the barrister who wasn't going to be in court, and yet you were then in the Court of Appeal arguing that this case should be delayed because I can't be there in person. And I wonder whether there was almost like a conflict of interest of being the person who's the subject of it, because I've never come across it where the barrister is the story. In a way.
That's really well spotted. In fact, it had happened to me once before, in a case before I took Silk, where I had to withdraw from a case because I was professionally embarrassed, which means, in short, my client told me something that meant I couldn't any longer put his case to the court. And the local authority in that case took issue with what I said. They didn't believe that I was telling the truth. And so that case had to go before a High Court judge to decide if I'd been telling the truth or not. That was quite a scary case. And in that case, I had somebody represent me. I didn't go to court, but somebody else did the case. So I've only just made the connection, really. But you're absolutely right. This case, I didn't want it to be about me, but it became about me. And it was a very, I've given an interview about this case on a podcast. And I was saying then it was a very exposing situation. And I'm looking back at the date of it. 10th of June, we were in the Court of Appeal, 2020, 3 months into COVID. You know, I was, like everybody, completely reeling from COVID generally, I was having to hit the ground running, as all family barristers were. Literally from day one, we got the remote court up and running. And in fact, I played a really big part in writing some guidance with the Family Law Bar Association for judges to use in how to manage remote hearings. And, you know, I think when we look at how the family courts operated in the UK compared with internationally, we know that we did brilliantly because our family justice system continued all the way through. And that was a lot of that was down to barristers and solicitors. So I'm just thinking back to the context of when this case took place. I was reeling from that. I was personally, you know, really worried. Couldn't see my daughter, who was trapped in a tiny flat in London, etc., etc. And all of a sudden, I was just in this case where it just felt really, really wrong that the judge was pressing on regardless with this case. And I developed a really good relationship with a client. I'd represented her for a long time. She was very vulnerable. And I had lots of people write to me from all over the UK at the bar, saying, really from unexpected sources, people saying, God, I feel really sorry for you. I'm so sorry that you're in this position. And what I was trying to say to the judge is it shouldn't be about me having to say I'm vulnerable. I mean, I was vulnerable. I was vulnerable because my wife was recovering from cancer, and also because I had my spleen removed when I was in my 20s. So it meant we were both vulnerable. And I don't mind telling people now, but I didn't see that I should be in a position where I had to reveal that in court. I look back now and think this case, it's one of those classic Court of Appeal decisions where they have to get a case through so they can make a decision about it. I was always going to lose this case because there's no way they could have said at that point in the pandemic, when everything was so uncertain, oh yeah, it's fine, it'll all be fine by Christmas, let's just adjourn all these thousands and thousands of children cases. So
Right.
I mean, this is quite a difficult concept to
explain.
Just
to pause there. So in a sense, they would have had to say, just to pause for a second there, if I didn't actually say, of course, the person you represented did lose the case, which meant that the judge said, no, we won't adjourn, we will push on with this case. This isn't grounds. The fact that the barrister has to be on person, will be online and not in person, is not grounds for adjourning this case.
Absolutely. And I'm looking back now, I see what the appeal said, and you know, they got it completely right. So they said, paragraph 22, it's in the public interest and in the interest of children and families that wherever it can happen in a safe and fair manner, the work of the courts should continue. This case provides a very strong example. So this is a really classic example of you as a lawyer having to fight when you know you're going to lose. I mean, I knew I was going to lose. You always harbour that belief you're not going to lose, because otherwise you can't do your job. You have to believe in your own case. But I look back now and think, what were you thinking? Of course you were going to lose. They were never going to say, oh, actually, Liz, yes, you know, let's wait until September, which is what I was asking the trial judge to do. So it's a good example of the politics, the interplay between judges and politics. This was a political decision. It was also the right decision legally, I think. But there was no way the Court of Appeal would have done anything other than say I was wrong. But it was really difficult. It was a very, very stressful, difficult, exposing case to be in, which is why I chose it to talk about.
Yeah, it's a really interesting case, because on one level it's about fact finding and it's a child protection case, and one of that's actually got nothing to do with it in a way. What it seems to, I mean, it is in a way, but it's actually really about public policy, online courts. They're really balancing what's the difference between a barrister representing somebody online and a barrister representing somebody in person. And when does that actually matter? And that really focused attention on the crux of debates that exist in academic literature about what happens in the room. How persuasive can a barrister be? Because on one level, the argument is, well, you can make the same arguments. You're going to make exactly the same legal arguments online that you are in person. So what is this? And in a sense that some people have argued in some of the literature about online justice that it would be better to have things online. Indeed, some people go as far to say we better have things by writing
Yeah.
only, because it takes out of play amazing personalities, that ability to sway the courtroom by
Yeah.
by your physicality and the way you by the performance, which of course why we love barristers and on
Yeah.
drama and TV, because it's this performing thing. But wearing a strict legal hat, that shouldn't make a difference.
Yeah.
Whether somebody's articulate or not, it should be the legal argument.
But it isn't.
So that's what the academic arguments is really playing with. Suddenly you've got this gold dust of a case that's really grappling with that, which is fascinating.
The other thing that happened, I'm just thinking this through now, the other thing that happened about 6-9 months later was that barristers actually got to really like being remote. We all did in family law, because you could do more cases, we worked out that we could still meet our clients and have proper conferences. When I was sitting as a judge, I did some really complicated cases, fact-finding hearings as a judge, entirely remote. I did one case where everybody in the case was deaf or had learning disabilities. We did it all online, all through interpreters. It worked brilliantly. So about a year or so later, when we were all arguing, actually, we quite like being remote, all of a sudden you then get the Lord Chief Justice and the head of the judiciary all kind of going, right, everybody back to court now. Because I think, again, politically, and you'll know more about this than me, politically, if you don't have courts, what do you have? What if you don't have courtrooms, what do you have?
Well, I wonder whether there is something about that day in court. The courtroom is such a physically important space. In imaginary, in civic imaginary, in public imaginary, and going to court is almost part of our language in a way, of going to court. But I'm sure these things will change. And wasn't the argument, I mean, what I have heard is that I know a judge who works in senior tribunal judge dealing with leasehold disputes, and she says that really is fine online. But actually people are saying family law is different. And I've spoken to other family judges say, I need to look someone in the eye, because I need to actually be with people. And what's interesting about this case, the judges do say, look at the original judgment. We're saying, well, this part of the case has already been determined. This bit's determined. What's left is just this bit. And that actually probably can be justified online. So they open the door to the possibility of being able to say, well, for some things, actually, it does need to be in person. The doors open a little bit in that case, I think.
I think it has, but I mean, I think if you separate out being a lawyer from being an advocate absolutely is theatre and drama, and that's why we do it, and that's why we love it. And there's so many skills, so many soft skills you have as an advocate that you just can't do online. As you say, reading body language, just waiting that extra little pause when somebody's in the witness box, and then you say, well, why are you hesitating? And you just become really adaptive and responsive to the behaviour. And that goes back to what we were saying at the beginning about being a social worker. It's about reading everybody's body language. It's about the drama outside the courtroom. So it's the going into somebody's conference room and putting your hand on the doorknob and saying, well, if you can't answer that now, we'll deal with that in court. And, it's all of that drama. It's all of it. I was taught when I was a pupil, I had somebody say to me, court is not for chatting. And what she meant by that was your performance, your role begins from the moment you walk through the court door, the court building door. You're on, you're switched on. And that means everything is of use to you. Every bit of body language you see, every overheard comment, everything is part of what you use to try and advance your client's case. And you can't do any of that online. It's really impossible. So
you're making a really good argument, but you're making a really good argument for the courtroom, having said that you're part of saying, well, it's fine, we did it great online and stuff. And I guess that's where we're all at. We're all recognizing that it's amazing online and if we having the same conversations in universities about online teaching and in-person seminars, and just trying to get the balance right. I'm sure every sector is grappling with this, every organization is, and it's really difficult.
The other thing that happened in family law, and there's some really good research by the Family Justice Observatory about this, about the experiences of our clients in public law proceedings. People who are on the breadline, who've got one device if they're lucky. How can they access the papers? or they've got their children running about at home, or they're living in a house with the abusive other half. And there are so, or they've got a disability, or just so many barriers to them participating. I'm not saying they're any worse or better than other barriers, like they haven't got enough money to get on a bus to go to the courtroom, or the court building is now 50 miles away because the HMCGS closed all the courts. But we had to work really swiftly at the beginning of the pandemic to kind of to think about how we were going to respond to those barriers, really, or those dynamics.
Do you think there's a difference between private family law disputes and public child law disputes in terms of child protection work, as opposed to disputes between in a relationship between husbands and wives and partners, in terms of online justice?
I mean, there is a reason that I don't do private law very much, and I think the clients are much nicer in public law. I'm not a big fan of, incredibly wealthy people arguing about which, prep school their overprivileged child should go to. Lots of people do it, and that's absolutely fine for them. I would much rather be doing care proceedings where I think the clients are generally nicer. They're you get a better relationship with them. It's what I know. It's what I've done for 35 years, I suppose. So I prefer care work, definitely.
Yeah, it's very different. And I know some people just wouldn't touch care work with a barge pole because they just find it too traumatic, too upsetting, just too disturbing, really sad stuff. That's why a lot of people don't touch family law at all, because they think the whole thing's tragic. I mean, there's no happy families in family law. You don't go into family law because you want happy families. It's in a way. It's
massively rewarding. I mean, if you get somebody's baby home, or, if you reunite a family, if you're for the family, or this week, the thing I've been doing in Preston, I had a man who, there were all sorts of findings made about him being violent. He's not a very nice man, but he still should have contact with his older children. And I managed to get him quite a good deal on getting his contact restarted, and got some resources in place for him. And I think I've done a good job. And I don't know, it's generally much more rewarding than saying, to Mr. and Mrs. Wealthy, oh, well, little Octavia can go to that prep school. I mean, I'm being very stereotyped, and I'm probably offending somebody, and I don't mean to. It's absolutely horses for courses. For me, I just like doing care work, and I'm not trying to denigrate it. It's incredibly difficult doing, I mean, there's some really difficult case law come out recently about domestic abuse in private law. Those cases are incredibly difficult, but it's just not for me.
No. I mean, I suppose the positive side one says about private family disputes is that the law is there to help people resolve disputes that can't. Even though I know that Sir Andrew McFarlane, the president of the family division, thinks that 90% of them shouldn't actually be coming to court in the first place.
That's actually why I started doing the arbitration training, because
and I wanted to ask you about that. This difference between being being a social worker, barrister, arbitrator, and judge. So you wear lots of hats. And I wonder, when you're being an arbitrator, when you're sitting as a judge and as a barrister, how do you switch all those hats around? And you really went, right, I'm doing this now. This is a different role. I can ask different questions, or to put it back to you and what you're saying, this is a different performance. This is a different show now, a different part.
I mean, it's really hard when you start. So I trained initially, my first judge job was as a criminal recorder. So I had to go and sit and preside over jury trials and things, which was pretty frightening.
Crown Court.
And that was, but actually looking back, it was really refreshing because it's so different. It's nice to get a break from the day job. So it's good to go do something different. On the other hand, the buck stops with you as a family judge. You're the one making the decision. And huge numbers of times as a barrister, I think, thank God I haven't got to make the decision about this case, because they're hard. They're hard cases.
Really, really hard decisions.
And I think it's a privilege to sit in judgment, on anybody. So you should take it really seriously. It's not something to be done trivially or lightly. You should, and I think if you don't feel that, you shouldn't be doing it. And I think anyone who does sit as a judge generally feels really responsible. Yeah, I suppose I've tried to learn it. I'm not very good at it. I've tried to ask fewer questions, but I'm not very good. I do chip in, and it's quite difficult not to run the case as you would run it as a barrister. And
Yeah,
if
I was
you've got
wondering about that.
bad advocates in front of you, that's very frustrating because but yeah, I think you just get up in the morning, you think, right, today I'm doing this job and tomorrow I'm doing that job. You just have to sort of delineate it in your mind.
I mean, one of the things we look at in the first year course is this whole issue of arbitration, and that whole debate, and something we're looking at next term, first year students listening in, is that whole debate about arbitration. Of course, a lot of an alternative dispute resolution, which arbitration's one form of, and mediation's another, which is very important in private family law. And a lot of the literature supporting that in an academic context is really hard on law. It's really tough on law and say, look, law's adversarial, everybody fights it, exacerbates conflict, it takes too long, it's too expensive, people don't end up in the right place. And alternative dispute resolution is all the opposite. It's quicker, it's cheaper, it's more accessible, it's friendlier, it's less formal. And they just, they've had this almost sort of a binary, law bad, alternative dispute resolution much better. They're quite messianic about ADR and stuff like that. And yet at the same time, I know lots of lawyers have qualified to become one. So why did you qualify to become an arbitrator? Because lots of barristers and solicitors I know are doing that. Why are they doing that?
Well, I enjoy being a judge. I'm not sure I'd want to be one full time, but I do enjoy the job of judging. And I think I do feel really passionately that service users, so the consumers of court services, should get a proper deal. So I think when you go to court, you should at least have somebody listening to your case who has got the time to have read all the papers, has thought about it properly, that you've got, as someone going to court on probably the most important day of your life, that you should be treated properly and respectfully, that you should have access to a cup of tea, you should be able to sit on a chair that's not broken, and you should just have a decent experience. And regrettably, 30 years ago, that was the case. I don't want to be depressing for everybody, but we're working in a pretty, if not broken, then certainly battered family justice system. And more and more and more, it was pretty much like this before the pandemic, and the pandemic's just about finished off private family law. So we know in chambers, cases get pulled regularly from the list. They get taken out of the list at 4 o'clock the night before. That means the client still has to pay the barrister to go. The case might then get adjourned off for another 6 or 9 months. They can't guarantee then who's going to hear the case. If you said to me, would you want a bench of unqualified magistrates hearing your very important dispute about what school your child should go to, or whether they should be vaccinated or not, or would you rather have a qualified professional judge? Well, obviously, I would say I'd rather have a qualified professional judge, but I can't always choose that in the current system. So I think I just thought it's an opportunity to try and deliver justice as opposed to consuming it in the way that I think is right. So I did an arbitration recently, did it at a very nice set of chambers in Birmingham. We had the whole day. It was a temporary, an internal relocation. One parent wanted to move to another town and the child needed to move school as a result. Both parents worked in education, not a huge amount of money, but, ordinary kind of couple. And we just did that case all day. That we heard the case on the Wednesday and the child needed to start school on the Tuesday. And they had my judgment on the Saturday morning. And the child then started at the relevant school on the Tuesday. And they got the hearings when they wanted. They had access to me whenever they wanted. I mean, they had to pay for it, obviously. But it wasn't prohibitively expensive compared with all the other costs of waiting. And I just did a seminar a couple of weeks ago about it with some other people. And we were all talking about, it just felt like a much more productive, much less adversarial process because we were able to be adaptable. So, for example, one parent changed their position on the morning of the hearing. So I was able to say to the social worker who was writing the report about them, can you go off into a room with the parents, talk to them separately, come back and tell me what you think. There wasn't any worry about any other case being in my list or anybody interrupting. And I just want to be able to deliver justice properly and fairly.
Yeah.
So that's why.
Yeah, I mean, it works. I mean, there's an image that often people use is the idea, you know, going to court is like this Rolls Royce, well, the old image of court before the courts were crumbling. You know, it's wonderful. It's like a Rolls Royce, and arbitration is this really nifty, clever little mini.
Yeah.
And it's not as good as a Rolls Royce in many ways, but actually it gets you there. It's quicker, it's cheaper, it's really nifty, and you can wheel them out.
And you can get out the car park quicker.
Yeah. And there was and I was involved in an arbitration case. This is years ago when I was an article clerk, and my client was being represented by, it was a QC then, and the arbitrator hated him because he was performing as if he was in the Court of Appeal and he was in an arbitration room. And an arbitration room, everyone listen, you know, it's just sitting around the table. It's very informal. And he was, you know, giving the whole big sort of, you know, present. And after each day sitting in the arbitration, he would come out and say, I can't believe he allowed the other side to ask that question. Why is he allowing that to take place? This is appalling. And, you know, we lost. And I could tell that the arbitrator really hated him. Because he was bitter, and he just wasn't, he didn't perform as if he was an arbitrator. He hadn't changed the performance. It was quite, and yet the barrister was really upset because he was saying, you know, this is really bad. This is not what happens in a courtroom.
Yeah.
But he wasn't in a courtroom. I wanted to tell him, you know, that was the point. But
I mean,
it was a very subtle distinction to draw somehow.
I think it lends itself really well to private family law disputes where people have become so entrenched. I mean, all the reasons I hate doing those cases as a barrister, because people become really unreasonable, they become completely fixed and intransigent. As an arbitrator, and in fact, I did think about training to be a mediator, but I think it's too much like being a social worker, so I don't want to go back to that. But as an arbitrator, you do have an opportunity to just try and sort of calm it all down a bit, really, and try and find a way through, because the damage to children of being caught up in long, protracted court proceedings between warring parents. I mean, the research is, you know, 50 years old about that. We all know what that does. It's dreadful. And so anything that can be done to take the heat out. I mean, I always say to anybody, don't go to court unless you absolutely have to, because it only ends one way, badly.
I mean, that's one of the things where academics want things to go to court, because we want Court of Appeal judgments and House of Law Supreme Court judge, because we love judgments. There's all sorts of cases I would love to go to court. But if I was a barrister or lawyer advising parties, I'd say, no, don't go anywhere near the courtroom. But until something gets to the courtroom, you don't have that judgment authority. I mean, there's an issue I'm very involved in is home education and homeschooling. And we actually do have a court judgment now, which has been terribly important for a long time. Some home educating parents have been saying local authorities are acting ultra vires. They shouldn't be doing this. They shouldn't be telling us this, that, and the other. And I was like, well, challenge it. And they did. They went to court and did a group action case, and they lost. I was pleased to say, because I was very much on the other side. But now we've got the judgment. And it's great because we've got an authoritative statement for something I've been saying for ages.
And it gives you certainty, all the things that we know why you need the law. You have to have certainty, and you have to have predictability, because you need, I mean, this case, 3C, I didn't like the result. My client was devastated. I was upset. But, we went on, and now we've got a case that tells us about COVID. And so, and Article 6 and right to a fair trial. And so that's how the law develops. So somebody's always got to lose.
Yes, it's a really important case for Article 6 right to fair trial for, non-family law students. It's a classic Article 6 case. And one of the things I think is really interesting, my final point about the case, is that while on one side you've got saying, no, you can't have any delay because it's children's rights, and because you've got to, delay is bad for children, guiding principle of the Children Act, etc. But on the other side, the argument that I think is really compelling is that children have a right for their parents to feel that they were fairly treated. And I've also found that argument, and I think your argument was that argument's not being given enough airspace, and it's a really important one.
Absolutely. I mean, this was a case where, just very briefly on the facts, my client had a terrible life, continued to have a terrible life, and was arguing, was fighting tooth and nail for her children ultimately to be returned to her. And so it was going to be returned to her or adoption. I mean, there was no real, it couldn't have been a more stark case, really. And so all gloves were off. We had to fight really hard as much as we could. And well, I've forgotten your question now. What was I trying to say?
Well, I'm sort of saying why a child having parents treated fairly is important for the child.
That's exactly right. So we were saying, the child needs to know, if that child's adopted, that child needs to know that his mum fought as hard as she possibly could for him, but also the child's got a right, and it's enshrined in law, to be placed with his family or her family as much as possible. The state intervening to remove a child should be absolutely an option of last resort. And so that's why ensuring the mother's right to a fair trial, we were saying, we lost, guarantees or should guarantee the child's Article 8 right to family life, because the child's got a right to be with his or her mother. And if you don't give the mum a fair chance and a fair trial, you've kind of squashed all over and stomped all over the child's Article 8 rights. And that's what we tried to argue, but it didn't work.
I do think those family law cases are often perceived just as, well, it's child protection, family law. Actually, they're some of the most important human rights cases. It always surprises me that adoption and child protection doesn't take a more center stage in human rights cases. Lots of human rights lawyers or human rights academics don't know anything about adoption.
I know.
I mean, it's one of the biggest human rights, and that's my hobby horse, so I shall jump off it straight away before I get carried away about that. And we're not going to go and talk about mum being BS, because there's lots to say about that. Now, there are lots, and we've been talking for about an hour, so I'm going to stop this part of the conversation and turn to the chat, because there's loads of questions coming up here. So I hope we're able to ask as many of them as possible. But okay, I'm going to try and get back to the top. Actually, there are loads. Yeah, there's a lovely one from Claudia. We're going to work from there. Have you ever dealt with the feeling of imposter syndrome?
Oh, constantly.
How long have you got?
Well, I'm a woman, so yes. Constantly. I mean, it was, you do. I think what you learn really quickly at the bar is a bit like anybody in any kind of performance art. You have to, you're paddling about madly below the surface, but you have to appear serene above. And you just have to kind of remember you're doing the best for your client. And as long as you're prepared, you just have to get on with it and do that. You do take knocks along the way, but I think as long as your motives for going into the job, I'm talking about the bar now, are sound, then that pretty much gets you through. But I'm afraid it happens almost daily.
It's a great question. I think most of us do, actually. I'm always suspicious of people that don't have an imposter syndrome. Actually.
I'm really confident all the time.
Yeah, exactly. Yes, but it's a real thing, and it can really be. Unless you acknowledge it and talk about it, it can really hold you back. So it is a really good thing to be open and to talk about. Teresa's asked, are there a fairly high percentage of people starting as a barrister 40 years old now? I know you probably haven't got the percentage figure, but
no, but I mean, I was just looking at our statistics just today, because that's what my E&D meeting was about. We've just started analysing our pupillage entrance by a range of different criteria now in a different way, and I'm really pleased to see that year on year people are getting older as they apply, and that's because we're really keen in our chambers and passionate actually about encouraging diversity. I can't say that's across the bar. I don't know what it's like at some sets in London, but I think generally now most chambers would accept that if you've got a bit of life experience first, you've probably got quite a lot to offer. So it's a really great career for the older candidate, I would say.
I have to say, writing references for Birkbeck students is a joy because you've got so much to talk
Yeah.
about and so many life skills. And when you talk about commitment and time management, think, yeah, somebody studied at Birkbeck for 3 or 4 years, but
Yeah.
there is evidence of time management here that's just overwhelming. Otherwise, I wouldn't be able to manage it.
When I had my first pupillage interview at the place where I actually got pupillage, they said to me, so Liz, tell us about your hobbies. And I remember just thinking, are you insane? I'm working full time, I've got a baby, and I'm studying part time. I've barely got room to, breathe, never mind have a hobby. So anything that a part-time student does, I'm always very keen to get part-time people who study part-time coming to Chambers, because I know how hard it is.
Music to our ears. That's fantastic. Anise is asking, are the costs less for running remote hearings? Because obviously in person, I mean, is it cheaper?
Well, only probably for the court, because they maybe don't have to heat the building, but the costs, no, the lawyers and the judges are still paid. Everybody still earns, thank God, because we did worry at the beginning of the pandemic whether we were going to earn any money. But yeah, no, not really.
I'm just going to come on. I mean, Teresa's asking some great family law questions. The one here, we've heard that in family law, judges have discretionary power. In a situation to decide a school, if you as a judge were against a public school versus a state school, how would you avoid intrinsic bias and decide what is best for the specific
child? Well, I knew that somebody was going to I should
Great
say my
question.
daughter went to a fee-paying school. So I really don't know why I said that. I mean, you just have to, as a judge, you just have to look at all the evidence, and you have to really constantly, it's a really great question. You have to constantly check yourself, because of course we all have conscious and unconscious bias. And so, yeah, you have to kind of really say to yourself, am I really weighing up what's in the child's best interest, which is, of course, what your number one question is, or is there a little bit of creeping bias coming in? And I think as long as you take the job seriously and properly, and perhaps I was a bit flippant about that earlier on, and I didn't mean to be, you just have to be balanced and apply the law and stick to what the law tells you about the evidence.
Yeah. And there's a classic question here. You mentioned having a client who wasn't a nice man with a history of violence. How do you reconcile having to argue on his side legally when on the other side, there are children potentially at risk of further exposure to violence?
Yeah.
Something that worries me about going into practice later, detaching emotionally. End of question. I
mean, it's a classic dilemma that you grapple with when you first become a lawyer. And it's a classic dinner party conversation, how do you represent someone you think or know is guilty? Well, the answer is you're there to represent your client, and if you believe that everybody has a right to a fair trial and a right to representation, that's what the cab rank rule is all about. You don't get to choose the people. You can't just represent the people you like or the people you think are going to win. I mean, most of my clients in care work have generally done quite unpleasant or feckless things. Some of them have done really dreadful things. I mean, your overriding duty in a family law case is not to put a child at risk. So you mustn't mislead anybody. You mustn't mislead the court. Your primary duty is to not mislead the court. But as long as you can satisfy yourself you're running your client's case and it's not putting anybody at risk, immediate risk of death or harm, then that's your job. You just have to get on and do it. And I think it's hard when you start. I'm not going to pretend it's not hard, but very quickly you become quite case hardened, I suppose. And you just have to really focus on the fact that your client needs a voice, and that's your job, and you're doing your job. So that's how you reconcile it. It's not for you to judge.
Everyone has a
No,
I suppose that's a classic case where actually you're not the judge, and in cases where it's not the judge. I mean, this follows on to the next question, which is quite interesting. How can you handle a hostile client during an arbitration session? And I just want to add to that question, the evidence or some research I've seen is that family judges are the most at risk of violence from people in the courtroom. And that's, how do you deal with that sort of aggression from potential people in the courtroom?
How do you, the risk of aggression?
Yeah, when there's aggression, because the parties to family proceedings are understandably angry a lot of the time, and that those are the courtrooms where there's the most recorded physical violence.
Yeah. Okay. I mean, you mean, how do you handle that as a judge?
Yeah.
I think that's where what I was saying earlier on about what are courtrooms for, what's the purpose of court. I think being a good judge is about establishing authority, but not in a kind of brutal, overbearing judgeitis way. It's about being firm but fair. And so gaining the confidence of the people in the courtroom so that when Mr. X starts shouting, you can say very firmly but softly, that's not the standard of behaviour that I want in this courtroom, and we've talked about that already. I don't want to see a repetition of that behaviour, and if I see that, I'm afraid I'll have no option but to ask you to leave, or something like that. You wouldn't go from 0 to 60 to that, but it's about setting the scene, and that's what I meant about why I became an arbitrator. You want to deliver justice in a fair way that everybody gets their say, everybody's heard properly. But we have legal rules for a reason. We have procedural rules for a reason, and it's to shape and manage incredibly emotional, difficult, painful, dreadful things that have happened.
Yeah, I mean, I think procedure is something that academics don't really talk about very much, but it's really important. It's often perceived as procedure is the dull bit of law.
No.
But in practice, it's not remotely dull at all,
No.
procedure. And there are some really fascinating cases about procedure, but they never really get taught because they're about procedure, which is, I really think that's academics' bias against procedure, because they don't understand how important it is.
The procedure gives a structure to managing an incredibly difficult conflictual situation. I mean, you're in court because of conflict. Either you're conflicted with the state or you're conflicted between two people, and somebody's got to find a way of managing it and shaping it. You can't just have a big free-for-all anarchy situation.
No, it really helps to fall back on that and resolving conflicts. Another question: have you ever gone away and thought you have made the wrong decision as a judge? Or worried about it, or it's preyed on your mind? And I suppose I'm going to add on to that. The question is that often judges don't know what happened next, so it's hard to know. And I know lots of judges I've spoken to, or lawyers, have said, well, we don't really know what happened next, and there isn't that, and that's quite hard because you don't know.
I really worry about those cases where I'm having the private law cases. I'm thinking about one which was, to use the technical term, which is a bit unfashionable, parental alienation. So it's where the mother accused the father of having so alienated the children against her that they didn't want to see her. And I had all sorts of, I heard that as a judge, and I had all sorts of expert evidence about it. And in the end, I decided to follow what the expert said, and I moved the children. I ordered that the children should be moved from him back to her, and they'd been separated from her for about 2 years, and it was really risky. And I did that on a Thursday night, and I came home. It wasn't too far from where I was living, and I got the bus home. I just worried about it all night. I really worried, had I made the right decision? And I was so relieved, because I worried that he would kill himself. That's what I was worried about. And I was really relieved the next day that, everything was all right and it had panned out okay. But I don't generally feel I've made the wrong decision. And that's not born out of arrogance. That's because you've done so much weighing up and evaluating, and you've worked it out in your head as you're writing it and thinking about it. You've pretty much argued against yourself the whole way through. You're carrying out almost an internal dialogue all the time.
Right. And in family law, that's important, because that's what will be looked at on appeal. Have any of your cases been appealed? Have you been appealed?
One. It was
what's
very
it
bad,
like when your judgments, and what's it like reading a Court of Appeal judgment saying, we think this trial judge got it wrong?
It was one of the most painful things. Talk about imposter syndrome.
No.
I mean, that was very painful. Yeah, and I mean, they say to you at baby judge school, oh, don't worry about the Court of Appeal, you know, it's there to help you, blah blah. Every judge I know really worries about the Court of Appeal. It was yeah, it was a bit of a blow. I mean, it took me a while to come back from that one, I must say.
Do you think they were right?
Yes, that was
Oh, no,
work. Well, I don't know. It was a relocation case.
Oh, they're very tricky.
No, I think I made the right decision, but they were right to criticize the way I got to a bit of the decision. Yeah.
Right.
That was
right.
nasty.
Yeah. Okay. And I want to ask a question that was asked. I'm following the chat, and then I'm going to lift the chat up and just ask people to sort of put the hand up if they want to ask a question, just using their voices. But one last question, because I'm not going to be able to go through everything in the chat, I'm afraid. One question was about surrogacy, and I know that's an area of speciality of your surrogacy law, and it's a really interesting subject because it's actually the Law Commission's got some work on this, but there's been discussion about there being legislation for a long time. And it really is one of those issues where, to quote the judge in your case, no perfect solution, this is a clash of rights. It's really complicated, and it's fascinating seeing the attitudes change so much, where people at our age, we've just, from what we remember reading, and it's just radically different. You feel like you're living in a different age. The textbooks look different, the cases look different. I mean, the starting point always was, in England, you don't do surrogacy. Surrogacy is not, commercial surrogacy is just an absolute no whatsoever. And yet suddenly there's all these babies, and judges have got to make decisions about these kids. It's a reality. You might not like commercial surrogacy formally in law, but there's a kid, and the parents need that relation to be regularized. Shouldn't the law recognize? How far should the law go to just speed that up? So what do you think is going to happen? And it's very controversial, because there's a whole surrogacy can include what may be happening in India or different countries, where and also voluntary surrogacy where expenses can get quite large. I mean, I know it's a minefield, isn't it?
I mean, what I think has happened is that the existing law, which is set out really in section 54 of the Human Fertilisation Embryology Act 2006, the most recent one. There's a whole range of criteria in section 54 which tells you that these are the things that the judge has to be satisfied about before deciding whether it's in a child's best interests to grant a parental order to the intended parents. And so a parental order is the order that effectively is like an adoption order. It's the only order that extinguishes the legal rights, the legal parenthood of the birth mother, the surrogate, and also the legal rights, if she's married, of her husband, and transfers the legal rights and legal parenthood to the intended parents, the commissioning parents. And so there's all these gateway criteria in section 54 that the judge has to look at. And what we've seen over the last 10 years, really, 10 years, is a gradual erosion of the strict application of those criteria. So to the point that, to be honest, you could get away with anything now and get a parental order. And so the one that the two that I have been particularly involved in that were, sort of groundbreaking cases. One was doing a case that expanded the statutory time limit. So it says in the law, it's there, statutory, it's a mandatory provision in section 54. You can only apply for a parental order within 6 months of the child's birth. Okay? They've just done a case, that was what the law says, 2006. There's just been a case this year made on a child who was over 18, who's actually now an adult. So how have we got from 6 months to actually anything goes, you could be over 18? So the case I did, which is a case called Re-X, was a case where I was reading the Court of Appeal decision in a case that had gone before me, where a Court of Appeal judge said, Well, it's obvious that, you know, Parliament was very clear about the reasons for the 6-month time limit. And because I was involved representing the child, actually, in that case, the new case, where it was over 6 months. And I thought, well, was Parliament very clear? I don't know. So I went back and spent a week locked in Lincoln's Inn Library reading Hansard, and found that actually Parliament had made it up on the back of an envelope, you know, the night before the final bill was read. There was no clear rationale at all. And so we won that case. And on the back of that, the time limit has gradually got expanded. And then I did another case called Re-Z, where again the law says only couples can apply for parental orders, even though the government had been really clear for decades that if you were single, you could adopt anybody. You know, it doesn't matter, you know, if you're single. In fact, you're to be encouraged as an adopter. But surrogacy is a much more complicated, difficult job. So we're really only going to give that to happily married couples. And so I represented a gay single man who went to America, had a baby by a surrogate in America. He absolutely had to get a parental order because he wasn't married. He didn't have a partner. He didn't have parental responsibility for his child in the UK. The surrogate in America, who never wanted legal rights over the child because she was a willing surrogate, under Californian law, was not the child's mother, but there was no parent in the UK. So the child had no legal status, no parent, no legal parent.
No
and so we
legal
changed
parent.
the law. We challenged the government's thinking, and the government, I mean, that was the thing I'm most proud of in my career. The government changed the law, and now single people can apply for parental orders. So the reason I say all those things is to illustrate that the law is dynamic and changing and developing. And so I think the way it will go is to remove these ridiculous gateway criteria and make it a lot easier. But we're still grappling with commercial surrogacy. Is it right for people to be paid? In America, they're paid quite openly. In other countries, they're paid openly. In the UK, we've got a terribly British, oh no, you mustn't do it for money. I don't know. It's fascinating.
It's wonderful, and I'm conscious of the time, so
sorry.
We could no, don't apologize. We could go on and on about surrogacy. There's so much to talk about, and so much to talk about. So many of the other questions that are coming up in the chat. Emma, great question. Best interest of the child. We'll discuss that more on a family law course, definitely in detail. I'm going to very quickly ask people, does anyone want to put their hand up and ask a question using your voice? Because I know some people aren't typing. Anybody? If not, I've got the final question, which Liz doesn't know, because on these legal practice conversation events, we always ask a hang
on, someone else got their hand up.
Yeah, Agnieszka. Okay, I can allow your mic. Agnieszka, do you want to ask your question then?
Hello.
Yes. You just need to unmute yourself.
Yeah.
Oh no, we can hear you. Good.
I think I think I have.
Great question.
I was interested in. You said that you are arbiter, so you kind of, one of your hats is arbitration. So I was thinking whether, you know, this arbitration decision, which are kind of not in court, can they somehow be used later on in court cases, either for you as a barrister in another hat, or you as a judge, or maybe somebody else?
That is a really great question. In fact, that's exactly what happened just recently in a case called Haley and Haley, where the Court of Appeal said that the arbitrator's decision, that was in a divorce case, a financial remedy case, and the Court of Appeal said that could be appealed. So up until that point, the arbitrator's decision was final. What happens when you give a ruling in an arbitration, the decision gets converted into a court order and it becomes final and binding. But now you've got this right to appeal. It's not happened yet in a children case. I'm sure it will, but it's happened in a financial remedy case. And that's considered to have opened the way now for arbitration to be seen as a much more user-friendly model for clients. Because if you're representing somebody, you don't really want to be saying to your client, well, if we lose at arbitration, there's nowhere to go. I can't appeal it. That's not a very attractive thing to be saying as a lawyer. But if you can say, well, actually, don't worry, we can still appeal, then I think that will, I'm not saying it will open the floodgates, but it's certainly trickling the door open.
It's really
Good
interesting because
question.
one of the logics, the arguments for arbitration is that will be if you agree to the arbitrator judgment. So that's fascinating question.
Yeah.
Quick question from Sarafu. Sarafu, do you want to ask your question? I've unmuted you, Sarafu. Your hand was up. Hello, Sarafu. Yep. Do you want to ask your question? Sarafu? No? Okay. All right. No, your hand is up, Sarafu. One going on. No, okay.
Oh no, hang on.
Yes.
Hello.
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 Yes, we can hear you. Yes.
Yeah, can you hear me now?
Yeah.
Faintly. Yes, we can.
Okay. Sorry. My question is, what advice can you give to someone who wants to study law or came from a forced migrant background and his first language is not English?
Okay. So what advice could I give to somebody
who want to study law?
Yeah.
But came from a forced migrant background and his first language is not English.
Okay. Well, I think if somebody wanted to study English law, then I think you do have to have a degree of English, of understanding of written English and the ability to communicate in English. And I'm pretty sure that most academic institutions would require that. I'm sure that Birkbeck would ask students to pass some degree of ability in English as a written and spoken language. But assuming somebody had that, then I think the best way to get into law is to immerse yourself in it. So to go to court, go and watch a trial, read as much as you can about law, watch any TV you can about law, and just meet some lawyers and go and see law in action. That's the best way that's what I did. And that's, I think, the best way to do it. And then you get to know pretty quickly if you think it's a career for you.
Yeah. Okay. Thank you for that. Now we're going straight on to Emma very quickly. To Emma, do you want to ask your question? Quick question, because we are running out of time and I've got the final question. I'm just allowing your mic and allowing your camera. Sorry, Emma. Very quickly, Emma. Yep.
Oh, I think she's still on mute.
Oh, you've muted yourself. No, that's Emma's muted herself. Disable mic. No, it is open. Okay, well, if that's not... Yeah, no, allow mic. I've got to allow the mic. I think you have to unmute yourself. Yusra, do you want to ask a question? Yusra? I've just allowed your... Yeah. Yusra. Yusra or Emma, you have to unmute yourself now. Emma, hi. Very quickly, Emma. Yep, we can. We don't have much time, so a quick question.
Just a quick question. I mean, legally, is it right for a woman to prevent a dad from seeing a child just because? Oh
yeah, we saw. Yeah, MOS. Yeah, we saw that in the chat.
Can you do that before the law and say, you know what, I don't want this child to have access to the dad? Is it right before English law? I didn't think it was. Is it? Very,
no.
I mean,
no, you can't.
No, you can't. But you might have to answer some nasty questions in court about it.
Okay.
Yeah. So, but there are often it's one of the most controversial questions in family law at the moment. So Emma, if you want to email me, I can email you some articles and chapters about that, because it's a really fascinating question that has been a really long-running debate between the father's rights movement and feminist commentators in the family court. So it's a great question. Yusra, last question to you before I ask the last one. Thanks, Emma. Do contact me. Yusra, can we hear from you now? Yusra?
Yusra's muted.
Okay. Yeah, Yusra, I'll have to unmute yourself because I can't do that from this end. Okay, Yusra, well, we're out of time, but I am going to ask the last question, which is, it's our sort of desert island. This is your luxury on the desert island question, which is, you have all legislative power. For a day, you're allowed to introduce a new law or change a law or repeal a law. Which one? What would it be, Liz?
Oh my God!
What would you like to see happen?
Great question. Blimey. Well, I would have said gay marriage, but that's gone and that's done and gone. I think I would like to be able to adopt my adult daughter, and you can't adopt an adult. So because I'm her non-biological parent, so I think I would like to be able to adopt her. So yeah, if I had a legal magic wands, that's what I would like to do.
That's really interesting, because under some legal systems, certainly in America and in Roman law, you could adopt adults.
I know.
And I certainly remember in California, San Francisco, back in the sort of AIDS crisis, before gay marriage, people they would adopt their partners, because that was the only way to protect inheritance. Because you can adopt an adult. It was the only way to recognise a legal relationship to a partner. So they actually used adoption law as a way, as the only option. Because, but no, great,
I'd
really
like to adopt her. Yeah.
Lovely. Oh, I really like that. Well, that's a lovely thing to end on. So thank you so much, Liz. It's been wonderful.
Thank you for having me.
It's been great. Thank you so much for joining us at our Legal Practice Conversation series. Tons more questions coming up, which we're out of time for our Maria Teresa, but we'll certainly be asking them carrying on with these questions certainly in the family law course and in legal systems and legal methods course. So thank you very much. I can see there's lots of thanks coming up in the chat now. That's great.
Thank you all.
And look forward to welcome you to Birkbeck in person sometime.
Yeah,
what we used to do when this is in person, at this point, we would go and have dinner. But unfortunately, we can't do so. Another time.
Okay,
thank you so much.
For having me. And have a good weekend. Bye.
Okay. Bye everybody. Bye-bye. Thank you.